We're going to look at the gender pay gap, diversity and inclusion, in particular with reference to the Bayfield case that some of you may have read in the press over the last 12 months, and then some steps to think about in terms of where we can legitimately look at positive action within the workplace and where we have to make sure that we don't step over the line into positive discrimination, which of course is unlawful in the Equality Act. Diversity and inclusion, and of course promotion and enhancement of diversity and inclusion in the workplace is an absolute key priority for employers. It gives us positives. Clearly, reports of statistics from ACAS, from the CIPD, all provide data that you can provide to your boards if in any way they are wanting to have that statistical information regarding the benefits of having a diverse and inclusive workforce. I mean, clearly, I won't read out everything that's on the slide here, but if your workforce is diverse, but you don't consider the views and you don't have representative inclusivity of diversity across your workforce at different levels within different functions and within managerial and director roles, then of course you're not necessarily going to be getting the best out of your workforce, and potentially being your biggest asset, is that going to potentially lead you to having retention issues down the line? And of course we're all looking at working towards a more diverse culture, representation within our companies. And with that framework in mind, we have the gender pay gap reporting requirements for large employers. And of course, this is now a key indicator that's reviewed annually, setting out the differences in pay within various quartiles within workplaces. And I know a number of you in the room do have to produce gender pay gap reports each year. Clearly, the pandemic has had an impact on the gender pay gap, and it's saying that the gender pay gap has widened quite significantly, in particular among full-time employees, although technically it is smaller than pre-pandemic. I don't have the stats on me today, but again, Michael, who's in the chat, for those of you, hello everybody who's watching online, for those of you who aren't in the room today, and welcome, can no doubt provide a little bit of link and information there. But we'll look at that, and particularly what happens when the gender pay gap report that comes out is unfavourable and looks quite high. And so this is the case that came out. And for those of you who are aware of it will no doubt be thinking, gosh, this was a horrendous case. But obviously it's a reminder, and it's a very cautionary tale as well, that the Equality Act protects workers from discrimination on the basis of each protected characteristic, including sex, of course, and therefore it does protect white males as well as it protects all other individuals of different other protected characteristics. And so the Bayfield case was relating to two individuals, two white men, who worked as creatives within an agency, a marketing agency. They were white, British, heterosexual, middle-aged individuals, both creative directors and obviously significant length of service within their organisations. And they were found to have been discriminated in their workplace. And that was set against the production of the gender pay gap report within that particular organisation, Wunderman Thompson. So their pay gap reported a median of 44.7% gender pay gap in 2018, which referred to the period for 2017. This was highest across the advertising industry that financial year. So the figures were quoted as very disappointing, and they were determined at the company to improve them over the forthcoming years. So they identified that they had an acute problem of female representation within the industry, and they decided to do something about it. And so shortly afterwards, they had a conference in which they produced PowerPoint slides. Again, this is where you can just see how it's going to play out, can't you? So in their PowerPoint slides, they said they had to do what it takes to ensure women remain in the business and rise to the top. Okay so far? Well, it went on. And the slide that they then produced stated in bold, white, British, privileged, straight men creating traditional above-the-line advertising, and those words were struck out because they were making it very clear that they were no longer going to have that image moving forwards. And speaking around this PowerPoint slide, they particularly made it clear that they wanted to obliterate their reputation of having straight white men within their business. So you can see where this then leads. Now, on that basis, they decided that they had a reputation of being a Knightsbridge boys' club, in quotes, and that they would do what it took to recruit more female talent and to retain that talent. Now, around this time, interestingly, they decided to commence a redundancy exercise. And you can just imagine who was selected as redundant. But in fact, it was beyond that. They actually, within their pool for selection that they created, decided that they were going to remove the only female within the team from the pool because she was a woman and for no other reason. And so, of course, that made that the whole process unfair from a fair procedure perspective, but also discriminatory, of course, and therefore that gave rise to sex discrimination claims, and the two males who brought the claim succeeded in their claims. So, where we go from here? Absolutely fine to look for diversity and inclusion within your employment and within your workforce. Really important, in fact. But actually, we need to stay within the line of positive action, which is, of course, lawful under Section 158 of the Equality Act, and not stray into positive discrimination, which is where, in the Bayfield case, the advertising agency got it horrifically wrong, and, of course, have now suffered the consequences of the bad publicity, the judgment, and obviously the high compensatory payouts that goes along with that. So, just be conscious of positive action over and above positive discrimination. And there are companies that are doing this well. Goldman Sachs, Rolls-Royce have been applauded for some of their positive action that they are taking to encourage greater representation of underrepresented groups within their workplaces. So they have, for example, widened their recruitment outreach programs. They are encouraging apprenticeships from underrepresented groups, such as female candidates, and also they're encouraging career break returners. And so obviously more likely to be primarily females who have taken a career break, for example, for caring or childcare roles. They are then encouraging returners back to the workplace. So there are ways in which you can encourage diversity without straying into positive discrimination, because what they're not saying is that they won't consider others inappropriately. On this side, there's another case, Furlong and Chief Constable of Cheshire Police, and in that particular case, a white, again, heterosexual male applied for the position of a police constable within the organisation of the Cheshire Police, so local, and he was unsuccessful because the police chose to give automatic preference to LGBT, black and ethnic minority or female candidates over and above white males. Who achieved the pass mark. But there was a disparity in qualitative data which showed that actually they weren't necessarily selecting on merit, and they were in fact selecting based on their proposed positive discriminatory choice of diverse candidates. And so that's where they got it wrong, and that was held in the tribunal not to have achieved the necessary test to justify discriminatory behaviour within the workplace, being, and again we'll look at this later in a little bit more detail with some of the discrimination cases, having a legitimate aim. Well, you might have a legitimate aim to have a diverse workforce, but is what you're doing proportionate to achieve that legitimate aim, or weighing up the potential impact on the group that you're discriminating against? Does that tip it into unlawful, unjustified behaviour? So a couple of steps to take. Again, I've mentioned a couple of companies that have been applauded for getting it right. And so think about the positive things you can do rather than the negative things that could be potentially neglecting a particular group or preventing them from having equal opportunity themselves, straying into positive discrimination, which is, of course, unlawful. And really just the final point to make is that although, of course, we have protection in equality and we have equality law, and we'll talk later about whether it's adequate or not, because there are a number of proposals to change and update equality law, which we'll come on to later. Obviously, the real inequality comes from cultural norms, societal norms, and I suppose that's our challenge, isn't it? It's to upskill, raise awareness, and look at identifying where we can make positive change in our unconscious bias, thoughts, and looking at very much training our workforce on diversity and inclusion. And again, for those of you who are looking at your training programmes for this year, that's absolutely something we'd be delighted to help you with. So thank you very much.